Hello, YouTube. We are going right on into the Executive Guide, complete manual for executors, administrators, and guardians. And we're going to continue from this subject. My other previous videos is basically breaking it down. So you look at my previous videos, you get the beginning of this. So I'm going to go where we left off at. Okay. Sorry me taking so long, but I'm trying to make sure. If I make a mistake that started earlier, it's okay. It's just the content that's what counts. Okay. I think I'm gonna start here. No, matter of fact, I think it start here. Okay, right here. Are wills and manners of execution. He may make this declaration himself, or in answer to question put to him by another, and it is not necessary even that he request any other to witness the declaration as his will. One witness, if credible, may establish the will before the surrogate of the county where the deceased resided, who will record the testimony proving the declaration made as a will, and if he consider it proved, he will issue letters upon it to the person named as executor. Let me see. As the executor by the testator, and it will operate as a valid disposition of personal estate. A mariner at sea, whether in the merchant service or the service of government, may make such will in the same manner. The question has arisen as the what constitute being at sea, and it has been held 8 N.Y. Rep 196 that a master of a vessel lying at Archer in a bay of an ocean, the land where the tide ebbs and flows, was at sea in the meaning intended by the statute, the point of the decision being apparently that because he was in tide water, he was at sea. It was held that the Delaware River opposite Philadelphia was not sea, what it is, Tacheria versus boat, former Gilpin R 524 Mississippi River at Vicksburg held not at sea. Matter of Williams Gorman, 1 Tucker 44 point, abbreviation. This rule, if carried out as it is reasonable to suppose it will include mariners on vessels engaged in the coasting trade, even if they shall die leaving such a will in the Hudson River at any place below Troy. In one English case, under similar statute, a mariner being on shore at Montevideo in South America received a wound and died, having first made non-cooperative will, which was held valid. A will may be revoked by the testator by destroying it, or by executing a new will expressly. Power to exact before proof of will. As to the powers and duties of the executors, named before offering the will for proof, one learning the fact of appointment as executor and the death of a testator, it becomes immediate duty of the person so appointed to decide whether or not he will take upon himself. Hold a minute now. Let me see. Messed up here. To do the executor before a will is proving in relation to the property of the deceased is regulated by statute 16 2 RSR 3R 5th 156. No executor named in a will shall before letters testamentary or granted have any power to dispose of any part of the estate of the testator except to pay funeral charges nor interfere with such estate in any manner further than is necessary for its preservation. From this it is followed that the executor name may sell the effect of the deceased to extent necessary to raise money to pay the necessary funeral expenses, and that he shall take charge of the estate to preserve it. In regard to what are proper funeral expenses, see hereafter. For the purpose of preserving the property, the executor need not take it into his possession or remove it from charge of the family of the deceased, unless he has good reason to suppose that it is being wasted and neglected, in which case he has power to take it, and he should do so for his own protection. He may he may doubtless convert into money perishable articles which cannot be kept long enough to be inventoried. Where the effects are in charge of persons not interested in the preservation of them, the executor ought to care for them and remove them, if necessary. He will be protected in taking steps for that purpose. He may take proper of the deceased and seal them up, awaiting further authority, and deposit them in a place of security. The will of the deceased should be open, and its content ascertained as soon as practicable after his death, for the purpose of learning of any directions are contained in the regard to his funeral or immediate care of his family. There is in some parts of the state a practice of waiting for 6 weeks after the death of testator before opening the will or taking any steps to prove it. This is founded in settlement and respect for the deceased, but it is mistaken exercise of it. For the best way to manifest such respect is to regard the wishes of the deceased and take immediate steps to carry them into effect, which can only be done by proving his will and caring for the estate which he accumulated for his family. In this connection, it may be well to state that the liabilities of any unauthorized persons taking possession of property of the deceased, as regulated by law 60.2 R. S. 81.3 R. S. 5th, ed. 168. When executor D. Son Tort afterwards takes letters testamentary, his responsibilities relates back to the death of this decedent or to his own first act of unauthorized interface, interstate Ellen Felwell of Tucker 110. Every person who shall take into his possession any of the assets of any testator or interstate without being thereto duly authorized as executor, administrator, or collector, or without authority from the executor, administrators, or collectors, shall be liable to account for the full value of such asset to every person entitled thereto, and shall not be allowed to retain and deduct from such assets for any debt due to him from the deceased personally in his lifetime, but he may retain any as such. We're going to continue on this.